All right, so this video is going to be an update on what went on with the Google LLC and YouTube case. And for those of you who don't know, we had a meeting, and in that meeting, I determined a lot. And I went from being kind of disgusted to actually being excited. I feel like no matter what happens, we're going to be fine. And I'll make that make sense here in a minute. So basically, the investigation was supposed to wrap up on December 18th that Google and YouTube were conducting to determine if they would settle something with me, or if they don't, the only thing I left on the table that I wanted was deplatforming of Goatis elections. Then my plan was to litigate. And so they also have to let me know what they think that they're going to do. So she let me know that would be to file a demurrer. So the court that I filed it in does have physical jurisdiction over this company, and I tied in the civil codes that prove that. And they have jurisdiction over the subject matter as well to a certain degree. But there is a lot of federal law that applies. There is more federal law that applies, especially under 18 U.S. Code. So the judge could end up agreeing with that, and that would give them federal preemption. She didn't use that term, but I know that's what she's doing. I always knew they could do it, but I kind of assumed that if they were going to do it, they would have already done it. But they first wanted all of my info first, and they also want more, and let me explain that in a minute. I have good arguments against the idea that I can't bring the case and that they wouldn't have liability toward me. So, but using more federal law for that as well, I might have an issue with the venue. So, one of several things can happen. I always knew that this could happen, and I could just file a motion to transfer, or the judge could remand it to the other court. But it would be dismissed without prejudice, which means I can refile the case in the other court with no problem. And also, she sounds like she's going to say that they don't have liability at all, civil liability towards me, a third party, which I definitely have good arguments against that. So let me explain the thing about the court, because why I chose that court. I chose that court for several reasons. Number one, a lot of district courts don't allow remote hearings at all. And this court that it would be filed in, because I have to have physical jurisdiction. And there goes my bird clock. On the matter of federal preemption, I filed in this particular court knowing it's not quite as good as district court for several reasons, and I worked that into the writ. District courts generally, a lot of them don't allow remote hearings, and it's up to the judge's discretion in the particular court I would have to file it in. And you have to realize I have to file it in a court that has physical jurisdiction over the company. So these two courts that we're talking about do. I picked the lower state court and tied in some state laws, which those laws, that company is bound by those laws, and they're along the same lines as the federal ones about the same subject matter. And then add to that the fact that I tied in access to justice law, which means here I am, a third party witness to crime, and I'm in another state. And I'm right now, November and December, I couldn't get away, couldn't go up here anywhere. So I needed a remote hearing in order to do this. And I think this matter is time sensitive, since we're talking about an incest killer guy. So that's why. And the judge could end up agreeing with me if I leave it right where it is. If I think that they won't, I could file a motion to transfer myself at any time, even while I'm in a stipulated agreement with them to be investigating the case and we're not into litigation. I can file a motion to transfer as long as I make them aware of it and the court as well. So I may be looking at dealing with that. If this gets filed, I'll tell you what we'll do. And then if it doesn't, I'll tell you what we'll do. If this gets filed, this pushes this into January. And we agreed that I'll amend my writ with my new information that I have. And by the way, let me let everybody know. I already knew that their main plan of action would be to get this kicked out of the court. And so in order to put a bug in her ear to make them want to, keep working with me, I told her I have more information that I would be adding to the writ if we litigate, and more law that applies to it, and that I wanted to send her some stuff. And I sent her some stuff, but not all. And that did exactly what I wanted it to do. So she did. That's what kind of perked her up to saying, we would file a demurrer. But you did say you had more info. So, you want to, maybe we can keep investigating and you can send that to us and amend your writ. I agree to that. But let me tell you what their plans actually are with that, because you have to realize, it's not like these are charitable. It's a charitable institution and they're just wanting to get to the bottom of something and do the right thing. They're protecting their client from liability, and that's all they care about. And they also are looking strategically at it from a legal perspective. And, I know the only way you can file a new case if it's ever dismissed your other case with prejudice is if you have new information and new law. And, there's a lot here that one can look at where these people and what they've done is concerned. So I do have that. And they want it all before they come to their conclusion. That's why they want to push it out so far. They feel like I'll just add it all, and then they can try to get it dismissed with prejudice. And then I'll be having a hard time ever filing it again in the other court. So that's their purpose. Let me tell you how we're going to beat that. And we could be doing the January thing, so we'll first look at that. I will send her more info, which I already did Friday night. So she thanked me for that and said she'd have her client look at it. And by the way, it's Google and YouTube really that are investigating this, not the law firm. Because the law firm is really only looking at the merits of the case, but I thought they'd be much more invested in looking at the details of the case, and they're not at all. She can't even pronounce Sferia. She asked me about the Rumble vid. She didn't even really know what was in the writ from what she said. I could tell. So that really kind of irked me. She just touched on certain points that they came back to her with that they wanted her to ask me about. So they're the ones conducting the investigation into him, which I knew they were, but I thought she would be, more invested in it than she is, or she'd at least have a paralegal doing it maybe that would brief her, because, that's what paralegals do. And I would think a firm that big and powerful would have a few, but whatever. So that was disappointing that I'm still like at square one. She can't say the names of these people. She doesn't know why I used Rumble videos in the writ when it's in the writ what I said about them, that it was to show what that he had a Sferia channel. The material on the Sferia channel was illegal, and here's an example of the type of videos he had, and that he was banned. And that's going to bring another issue up here in a minute, but let's finish this part. So anyways, so that's what the lawyer is doing. That's her purpose, and that's how little she knows about these other aspects of the case. So what I would do is I would amend the writ and send them some information, but I would right away, if I deem it to be worth it, to transfer the case, because a lot of the new law I would apply would be federal, and I think we are going to get into a situation where it's more federal than state. And now that we're not in a situation, November and December, I couldn't get away. So I knew I had to have a remote hearing. And that's why I put into the writ law pertaining to access to justice, and that this is something that is time sensitive. There are people at risk. So I need to do it now. And I want you to agree to do it here so that I can appear remotely, with a guarantee of appearing remotely versus the other situation, which would be up in the air. So January, I could actually do it, so it wouldn't matter as much. So I could take that risk. So I might file a motion to transfer, which I can do even while we're not litigating. I can do that during the stipulation period, and I won't be breaching our stipulation. But I will say this: if the company isn't really investigating this properly, then they violated our agreement already. Because I don't see how they could be investigating it and coming to the conclusions that they are, that they don't want to do the one thing that they are legally obligated to do, my opinion. But we'll see. So that's something I'll be thinking about. I can leave it where it is, or I can file that. Now, here's what happened with the stipulated agreement. So this is just kind of typical of what goes on. We're supposed to confer before December 18th. So she picks Friday, this past Friday. And we talk and we come to an agreement pretty quickly that, she wants to extend this into January. And I say that I agree to that. So she goes and makes sure her client's okay with that. and then she just needs to draft the agreement and send it to me, which I expected to see Monday morning because we have till Wednesday. I don't see it Monday morning. I don't see it Monday afternoon, and then it's getting into the evening, and I decide I better write to her and say, hey, and it was about 3:30 her time, and I said, don't see anything. Want to make sure I didn't miss it, and if you can send that to me, I'm ready to look it over, and if it's as we said, I'll sign it. And 10:30 at night is when she sends that to me, and even put in there that we only have one day, so please make sure we do this as soon as you possibly can. And I'm like, yeah, duh. So I told her that night I authorized my signature. So this morning I don't see anything, and we're all the way to it's now 2 o'clock. I haven't gotten anything back. I did write to her at noon asking, please let me know when you file that with the court. And she said that she would let me know. They have a little administrative thing that they have to do first, and she'll send me a courtesy copy. So they haven't even filed it yet. So one thing to note also is that if you breach the stipulated agreement by doing something outside of the bounds of that agreement or not doing things that you said you'd do, you can the other party can ask for the judge to rule in their favor. So I could argue that they are maybe breaching the stipulated agreement by not investigating the case. And I'll argue right now that I do believe that might be why they didn't want to have the CMC meeting. I always thought that, because then we'd have to get in front of the judge with what we've got, and they would have to showcase what they have or have not done. And boy, if she got in front of a judge not knowing how to pronounce the guy's name and not knowing what was in the writ, that really wouldn't look too good. They wouldn't have been able to treat it that way. They would have had to at least go in there knowing something and citing that they'd done something and why they are or aren't doing whatever they are or aren't doing. So that's why they didn't want to have that meeting. They want to get rid of this before they have to, get into the facts in front of anyone. But they want to have all my facts and have it be where I can never bring this anywhere. So we know kind of how to go around that, because I really want to get this over with. And I, at this point, feel like it's so rock solid. They wouldn't be doing any of this if it wasn't. So, I'm going to try to just beat them. Then I will file my answer to that, which will also include a motion to transfer if I myself also agree that we need to have a new venue, and that's the main legal problem. Any other stuff they cite, I'll of course combat it. I can cite everything about why they're liable to me as a third party. You can go after a corporation this way. It's just rare, but it happens, and it's legally sound. So under state law and federal law, but I may put the motion to transfer myself in there, and then. But the judge, what she could do with this is she could say, I remand it to the other court. It is a valid case, but it needs to be remanded to the other court. If I do a motion to transfer, she could honor that. And if I don't do anything and I just make my legal arguments against what they're saying about how both things apply, the judge might file a motion to dismiss without prejudice, meaning I can file it again in the other court on my own at any time. Or she could file one with prejudice, which means that I can only file a new case if I have new evidence and new areas of law that I'm touching on related to this matter, and I do. So that's taken care of. I can always either just file this in the other court or it gets remanded there, or I can file a new one. I will be amending the writ, and I will maybe do the motion to transfer myself, and then if not, we'll leave it where it is, and I'll amend the writ. And if they don't do what they're supposed to do, we'll litigate. But what I'm thinking is I'm going to give them the first couple weeks of January, and I'll be giving them some new information, pieces at a time. And if I can see that they don't do with that information what they should be, I can go to the court and I can say they're breaching our stipulation, and or it's a dangerous situation and I ask for an injunction, which means they have to immediately provide the relief I'm asking for, which is to deplatform him. And this time I'm also going to add in the injunction that I want his information sent to law enforcement and Primal Bells. I'm not going to take her off the table anymore either. I don't have to. So let me make it clear. Under 18 U.S. Code ECPA law, it says that if someone is in imminent danger which that little girl is, and also Diane and her son are. And let's face it, the public are, and that's part of an injunction. It has to be, there are things about either yourself or the public, so it's possible that that wouldn't be granted, but I really think it's possible that it would be. So if I can prove up that they need to give me an injunction, then they would have to do what I'm asking for immediately. So that's another way to get that done. So, and I would make that part of any case now. If we have to file a new case, that's going to be filed with the case. And because they're wasting all of this time and putting people at risk. But people ask, like, why would they do that? You got to realize, like, the way they look at things, Toyota knew that their gas pedals were sticking and people were dying at one time with one of their vehicles that had that problem. And many, many, many more people died while they did not recall the car. They knew about it. And why didn't they recall the car? Because they felt like those wrongful death suits were going to be cheaper than recalling all of those cars. So that's how companies think. That's all they think about. So we're looking at this very differently than they are. So just remember that when you're dealing with people, and kind of you have to look for what they're more like Goatis than we are. So we have to look for what they're actually trying to do. So I do want to especially thank the ghost of James Uganda. He brought up something to me the other day that I hadn't thought about. And it was just kind of like, because we are dealing with a pathological liar. So why I assumed he was telling the truth about being banned, I don't know. He may not have been banned. We do have to look at the time frame of when he went down. October of 2022 is about when the channel would have gone down. November would be the PayPal and the Patreon went down. And then Diana's attacked in May. And then her home was burned down 2 attempts in January of 2023. So, he may have wanted to wipe the slate clean on his social media, and that could have been strategic. Also, you'll get donations if people feel bad for you for being banned, obviously, and think you're a poor little victim. So, and that's his whole life story, is that he's a poor little victim. So, and isn't it funny that they run around projecting onto the victim that she's trying to be a victim, but she actually is a victim and would just like to stop being victimized. That's all she's ever asked for. And they want to be victims very desperately. So it's very possible that he wasn't even banned, and as he should have been, and that a lot of people were also asking for him to be banned back then, and that company's worried about all of that. So either way, though, I will bring up that he was off and telling people he was banned. So if he was truly banned, then there is the ban evasion aspect, which means they're violating my rights as a contract holder with Google and YouTube, and all of your rights. You're contract holders with Google and YouTube. You're obligated to do and not do certain things, and they're obligated to hold the same standard for everyone. So that would be the case if he really was banned. If he wasn't banned, he lied about it, and they can see that he did. And all the other criminality that I've been bringing up all along, of course, is being highlighted. That proves up that either way, when you've done that kind of criminality on any channel, you can't have another one. There's law pertaining to that. That's in my Telegram writ, because he's never been banned from Telegram. But I'm citing all of the criminality going on his other Telegram channel and on this one, because the criminality on the other Telegram channel, which is really excessive, can tie into why he can't have the current one. So yeah, it could be him taking down these channels and things of that nature. So really important thing to think about, and it makes me feel a little less disturbed by their behavior, though, even though I still am, because if they can't do it on ban evasion, maybe if he wasn't banned, and they want to look heavily into the criminality and see what they did and didn't do and when and stuff like that. So we'll give them the benefit of the doubt a little bit on that, and just protect ourselves as well, protect the case. And some really important information. There are things I didn't see in the past back when I first even knew any of this was going on. And I saw that video where he doxed Luna and did all that disgusting stuff. I didn't know, what would go on in the future. I hoped she'd get away from him. And hoped he'd move on with his life and people would see that he was a scumbag and he'd lose his following. That's what you always hope with bad cult leader type people. But, and that's kind of happening, but it's not happening without a lot of great harm happening first. That's one of the things this company is worried about, because no telling how many people were flagging that stuff and trying to get their attention and get them to stop him, and how many real people looked at reports, which if they looked into it could be proven up. So anyways, it would be, it's not going to help them to drag this out and to put people through more to try to get it done. But that being said, there were some things Gaddis did and said toward Luna and toward other people that I haven't seen. And so there's some facts now, names and other things that I have that I didn't have before that are very helpful and will go into the amended writ, whichever court it's going to end up being heard in, because we still have a case and this is still not over. So that's what we're going to be doing. And I think everybody should enjoy their holidays. And I was hoping this would be like a pre-Christmas thing that would happen, but it's probably not going to. So unless the injunction thing works, I might try that while we're doing this stipulated agreement. If there's a good legal basis to say that they breached our stipulation, or that they currently are, we'll see. But I do think this is going to go into January either way, because even if they file their dimmer, I'll be answering it and stuff. So everybody just kind of relax, even though this is a timely matter. We're going to try to get something done by January, but that is kind of how this is going to go. It's going to go back and forth a little bit.